Okay, guys, we're going to go ahead and start. First of all, thank you for showing up. Thanks for coming to this. I am Colin Kalmbacher, the outgoing president of the American Constitution Society. And to start us off, I'm going to make a pitch for membership. It's $10 a year for students, and we have a goal this year of 10 new members. We have 3 so far, so 7 isn't really a huge stretch. We think we can make it. And of course, that all depends on you. A little bit about ACS. We have monthly film screenings. We do events like this, typically every month as well. Last month we had a voting rights panel. Next month we'll have a panel on medical marijuana, marijuana legalization in Colorado and Washington. And our film screening this month is about drones. We have flyers and membership sign-up forms. Those are right down there. And if you want to go ahead and, if you haven't signed up already, make sure you go ahead and do that. The mission of the American Constitution Society is to promote the vitality of the U.S. Constitution and the fundamental values it expresses. Individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. And we are very pleased to be able to work with the Bill of Rights Defense Committee and the Executive Director, Shahid Buttar. The Bill of Rights Defense Committee is a national, nonprofit, nonpartisan organization working to ensure the restoration of the rule of law and our constitutional rights and liberties. The BORDC aims to make police and intelligence agencies accountable to we the people whom they serve. BORDC supports an ideologically, politically, ethnically, geographically, and generationally diverse grassroots movement focused on educating Americans about the erosion of our fundamental freedoms, increasing civic participation, and converting concern and outrage into political action. Shahid Buttar is BORDC's Executive Director, and he leads the Bill of Rights Defense Committee and its National Grassroots Network in their efforts to defend civil liberties and constitutional rights threatened by law enforcement and intelligence agencies. He's a constitutional and civil rights lawyer, an independent columnist, a grassroots organizer, a movement strategist, a hip-hop and electronic MC, and spoken word poet. Shahid's comments have been featured by news outlets including the Washington Post, the New York Times, USA Today, CNN, Al Jazeera, Fox News, Agence France Presse, Huffington Post, Truth Out, Democracy Now!, and many, many others, including dozens of radio stations across the country. He frequently addresses public audiences such as elected bodies, colleges, and law schools, including Stanford, UC Berkeley, UCLA, the University of Chicago, the University of Texas in Austin, Georgetown, and now for the second time, though the first time as Texas A&M School. Shahid has performed around the world, co-founded several grassroots art and culture groups around the country, facilitated workshops for young people and emerging artists, and released his debut CD, Get Out of Your Chair, in 2008. He will be introduced for the second time, and this event will be moderated by our own Sahar Aziz, who teaches torts, as I'm sure everyone's well aware of, national security, civil rights, and Middle Eastern Islamic law, right here at Texas A&M. Professor Aziz has served as a senior policy advisor for the Office of Civil Rights and Civil Liberties at the U.S. Department of Homeland Security, where she worked on law and policy at the intersection of national security and civil rights. Prior to joining DHS, Professor Aziz has litigated class action lawsuits involving civil rights, alleging a nationwide pattern and practice of gender discrimination and discrimination. Professor Aziz began her legal career as an associate at Wilmer Hale in Washington, D.C., where she conducted internal white-collar crime investigations and an independent investigation on child trafficking and push control. She also clerked for the Honorable Andre M. Davis on the United States District Court for the District of Maryland. And I'm going to go ahead and short-circuit the rest of these introductions because I know they tend to run a bit long, and I feel like everybody hates it, and I hate it too. When I continue to read from the paper, I have to make eye contact, and everything goes a bit faster, and it's a bit more lame. So if you recall, Shahid Buttar is a MC and spoken word poet. In 2008, he released a CD called Get Out of Your Chair. And so I'm not asking you to, but you can go ahead and do that if you want to, or you can stay in your chair. But let's just go ahead and give him a warm howdy and round of applause.
And before we have our guest speaker, I just wanted to make a personal introduction of Shahid. He is an old colleague, a good friend, someone I used to work in the trenches with. Yes, before I came here, I actually was out there in the war zone that I'm trying to prepare you for. And Shahid is someone who I hope all of you will one day become in your own areas. He strives for excellence. He is very committed to the cause that he believes in. And he is also someone who has, I think, the utmost intellectual integrity. And I hope, I'm not sure what the political ideology of our audience is, but it does, you don't have to be a leftist or a liberal to be here and to learn about these issues. And I think that whatever place you sit on, left or right or center, the most important thing is that you're intellectually honest and you have intellectual integrity. And I think we're very fortunate to have Shahid, who is one of the few that fits into that category and still doing advocacy. And before I bring him on, I want to just put a plug in for my class, which I know many of you are thinking, I will never take a class with that woman again. But you will be. Some of you even miss me, I think. You don't have to admit it, though. So, counterterrorism law, national security law, I'll be teaching it in the fall, 9 a.m. in the morning, which is very early. But I did it so that you all wouldn't have conflict. So it was actually a sacrifice to try to recruit you to my class. And there will not be a final exam. It's all simulation. And drone attacks and targeted killings are a subject that we will be discussing in addition to many other national security related issues. So I hope that you all consider coming back to me. And I hope that Shahid is, and I know, I'm confident that Shahid will trigger your interest in these issues. So without further ado, let's welcome Mr. Buttar.
Thanks for coming in for your very warm welcome this morning or afternoon. Two just brief plugs. First, it's great to see so many of you out here today to learn more about these issues, and just for your reference, I'm going to do this as Socratically as possible to engage you, and also for my own reference to get a sense of what you've heard here at Fort Worth about the issues that we'll be talking about. Two quick plugs. First, for ACS, I served as the communications director at ACS in DC for 3 years in the mid-2000s, and would highly recommend it as a network through which to expose yourself to the full range of issues that concern our society. Sahar had mentioned the question about ideological balance. I find myself in the increasingly strange position of a progressive who gets more play from Republicans than Democrats. We can talk more about that later. But it's an interesting network, and you'll get exposure to a lot of different kinds of ideas. And I think that as law students, that's a particular opportunity that you should avail yourself of, especially because you're getting acquainted with the tools with which you can leverage those kinds of experiences. But legal education, in a formal sense, tends not to expose us to the full range of alternatives, right? And that's something, actually, a theme that we'll get into in a minute. And at the request of my colleague, Professor Aziz, I would just note, I gather she suggested to me that some of you might know her as the very rough torch professor, and I would just suggest to you that however rough any of your professors might seem, it will pale relative to practice. So get used to it and take it while it's good, is what I would say to you there. So my theme of my remarks today is going to be the corruption increasingly apparent across the national security establishment. We're going to use two particular policy lenses to examine that issue and the confluence between them: NSA spying, which has been in the news for the last year, particularly this week, and I'll try to encompass in my remarks some reflections on the President's recent proposals, well, forthcoming proposals. They actually haven't been detailed yet, and then the new bill coming out of the Intelligence Committees in the Senate and House. The other issue relates to CIA torture and the current battle between the Senate Intelligence Committee and the CIA with respect to whether to and how much to release of the Senate Intelligence Committee's 6,000-page report on CIA abuses to the public. It exposes or introduces to the equation not only issues surrounding human rights and government transparency, but also the added sort of confluence of spying not only on Americans, but particularly on congressional overseers. So before diving in, let's just set the stage with the NSA issues. And I would love if anybody wants to give us a 30-second recap on the Snowden revelations and what they've kicked off in D.C. Any takers? Come on, you guys read the news, right? Tell me you read the news.
I'll volunteer.
Go for it.
Okay, so we, in conjunction with Glenn Greenwald and The Guardian, Ed Snowden leaked out thousands of NSA documents that contained all kinds of secrets that were not able to be declassified. So Mr. Snowden went to Glenn Greenwald, the Guardian, to do so, and in doing that, it essentially caused a huge falling out. And we're still having a discussion. Mr. Snowden is, I believe he's hiding out in Russia. And so there's discussion that it's all kinds of civil rights discussions going on, whether there should be transparency and whether we should be able to know what's going on and what the government's doing going forward.
Great first take at it. Any additions before I jump in there and try to fill a few gaps? Anyone? Okay, great. So that was perfect in setting the stage. And what Edward Snowden did for the public debate was essentially enable one where for a decade none had existed. The government since 2002 had been essentially tapping the back end of the internet and the phone system, monitoring essentially everyone, at least internationally and also in America. The penetration of the call record telephony metadata program reportedly could be as low as 60% of the United States, but the point is, you need have done nothing wrong to have been monitored and spied on by our government. Another way of looking at this is that we today in 2014 in the United States live in the most heavily surveilled and monitored society ever in the history of humankind, with the possible exception of contemporary China. And I do mean particularly to suggest that the former East Germany and the Soviet Union had much less pervasive domestic monitoring capabilities than the National Security Agency, the FBI, the constellation of agencies under DHS, and the state and local police departments, which together facilitate the domestic national security surveillance establishment. It might be news to you that it's not just the federal government doing this. And that's another theme I want to draw out here. So with respect to the NSA issues, what we learned from Snowden was particularly offensive to privacy advocates. To people concerned about civil rights in America, the history of government surveillance suggests a whole range of further concerns beyond the discrete revelations of NSA spying. So I'm going to share an amalgam, a word, and I'm going to ask if anybody's heard of it. COINTELPRO, does that mean anything to anyone? No one? Anybody? Go for it, Colin.
The counterintelligence program was basically a project of the FBI under Herbert Hoover during the 70s to explicitly root out radical left-wing organizations, including the Black Panthers, the American Indian Movement, and other assorted organizations. The thing that particularly struck the FBI about the Black Panthers was their free breakfast program for inner city children. And basically it was used to essentially infiltrate and destroy through various methods a bunch of leftists and left-leaning organizations based in the U.S. in the 70s, I'd say, mostly the 70s.
Started in the 50s, ran through the 70s. That was exactly right. So in 1976, the U.S. Senate and House concluded multi-year investigations into our domestic intelligence agencies. At the time, principally the FBI. The NSA existed at the time, but had not, the SIG and signals intelligence capabilities of the agency had not emerged to the same level of rigor, let's say, that the agency enjoys today. In the COINTELPRO investigations, the principal agencies that figured in were the FBI, the CIA, and components of the Defense Department, the Pentagon, that were also engaged in spying on Americans. And just to flesh out the range of groups that were impacted, it absolutely did include the Black Panthers and the American Indian Movement. It also included the mainline civil rights movement. The most famous target of the counterintelligence programs was the Reverend Dr. Martin Luther King Jr., who the Senate found a documented campaign to drive to suicide concocted by the FBI, and this campaign was successful with other civil rights leaders. There's a French-American actress people tend to forget about named Jean Sebring, who killed herself because the FBI planted a fake letter with her husband claiming that her unborn child had been fathered by a member of the Black Panther Party. And these are, FBI informants entered into fake marriages. These are to say marriages in which one person thought they were getting married to someone and the other person was an undercover government agent. Try that on. And some of the movements that were particularly impacted by the COINTELPRO scandal, let's say, included the movement to end the war in Vietnam, the movement for equal rights for women. It wasn't just left radical groups. That's the only place I guess I'd press back, is that it was a broad swath of the American public that was targeted by the counterintelligence program. So the reason I introduced this is that the NSA's spying on the American people is not new. It's well established. It's what our intelligence agencies do in the United States. And you might have heard a different narrative, particularly under the Cold War, when we blamed the other side of the Iron Curtain for doing those things. Unfortunately, the distinction is more rhetoric than reality. So before we turn to the CIA, the last things I'd say on the NSA. First, the two different presidential review panels, both the Privacy and Civil Liberties Oversight Board as well as the President's Review Group on Global Signals Intelligence, concluded that in not a single instance has the NSA's dragnet spying regime ever actually helped stop any actual incident of potential terrorism. Which is to say, claims about the program's necessity are at least unproven. There's been no evidence to suggest that they're even helpful, let alone necessary. Another piece worth noting is that the revelation of these programs did and has sparked a robust controversy across the political continuum and across all corners of our great nation. And it's reflective of the gulf between, I would say, the DC institutions, and we're going to unpack each of them in a second, and the rest of the country. So the DC institutions involved in NSA spying include, obviously, the NSA. After the COINTELPRO investigations of the Church and the Pike Committee in the 1970s, the Senate and House each created standing committees, the Senate Select Committee on Intelligence and its House counterpart. These were oversight committees created to oversee secret intelligence gathering operations. There's a sensitivity here, right? Intelligence by its nature can't be fully public, and so the idea was to have, welcome, the idea in particular with the establishment of the intelligence committees was to create bodies that were capable of examining intelligence collection, grappling with its secrecy, but still providing a modicum of democratic oversight. And what we see in the phenomenon of the NSA spying programs persisting for a decade before finally prompting public controversy is essentially the erosion, or I would put to you the co-optation, of each of the three branches created by our founders to check and balance one another. So let's just zoom in, and we'll use the NSA example as a crucible, and then we'll flip to the CIA torture issues, and we'll examine how each of the three branches relate to the programs at issue. So the executive branch agency complicit in NSA spying would be the, I just said it, NSA. What's the congressional or the legislative oversight body? We just talked about that too. Senate and the House intelligence committees, right? What's the judicial analog? This is a bit tricky. Fisa Court. Now, let's look at the Fisa Court briefly. Does anybody have any insight into how the Fisa Court might differ from what we know generally as people who study the law as courts?
I don't believe there's a public representative, that like a public defender for civil rights issues or anything like that, to my knowledge.
Yep, and I think what you're pressing at is that usually in courts, we think of courts as adversarial bodies, right? There's an opportunity for both sides to appear. If only one side appears, can you fairly call it a court? What if it meets in secret and its decisions can't be cited? Is that a court at all? Have you ever heard of a court like that? It's not particularly judicial, is it? Right? I mean, so that's one thing I want to draw out here, is the creation through the statutory framework, particularly in the FISA, that's the Foreign Intelligence Surveillance Act amendments of 2008, which amended one of the post-COINTELPRO statutes that Congress implemented in the 1970s, the Foreign Intelligence Surveillance Act, which aims to take the CIA out of the business of domestic surveillance and created particular standards for domestic surveillance that were higher than in the foreign intelligence context. The idea coming out of the COINTELPRO investigations was, okay, we might not mind the CIA or the FBI conducting intelligence gathering operations targeting foreign entities or national security threats. But when we're talking about we the American people, particularly when exercising our First Amendment rights, we don't want the intelligence agencies laying waste to our most fundamental freedoms. And that's what compelled the creation of the Foreign Intelligence Surveillance Act, the Attorney General's guidelines to constrain FBI abuses. It was those particular standards that were watered down in the past decade in the furor and controversy following the 9/11 attacks. And I want to particularly zoom in, again, on the 2008 reforms to the Foreign Intelligence Surveillance Act. That was the moment in time when the contemporary NSA spying issues were made legal, despite their continuing unconstitutionality, despite the statutory subversion of the Article III judicial independence on which our legal system rests, and despite the very profound threat to the First Amendment rights of speech, association, and the right to petition your government for redress of grievances. So questions on the NSA stuff before we turn to the CIA? And we'll get into a deeper discussion, but just I'd like to invite your questions foundationally on what we're talking about today.
Who appoints the judges for the
Fisa Court?
Fisa Court.
They're unilaterally appointed by the Chief Justice of the Supreme Court, which is to say John Roberts, I'll say it non-normatively, John Roberts has carefully selected the judges for the Fisa Court. I would pejoratively say that as the Chief Justice has stacked the court with, as the Supreme Court is currently composed, judges who come from the executive branch and are inclined to defer to it.
Are there term limits?
There are not. Any other questions before we turn to CIA? Okay, so a question for you. Does anybody want to share with us 30 seconds on the CIA's torture program under the Bush administration?
They could pretty much do whatever they wanted.
It's fair, yeah?
Well, I actually just watched a show on this the other day, and they said that they were only allowed to do the harshest treatment they were allowed to do was waterboarding. And this was all done at black sites or whatnot. And, you know, it was effective, they said, to for the quote unquote terrorists to admit to certain information.
So I'll agree with pieces and differ on others. So the CIA under the Bush administration conducted what they called an enhanced interrogation program. And this was authorized at the highest ranks of the Justice Department, particularly the Office of Legal Counsel, and it included, there were memos in which the Justice Department approved the CIA's use of interrogation methods that would do anything short of cause major organ failure. That was the new definition of torture that the Justice Department contrived under the Bush administration. So under that definition, pulling out someone's fingernails would not be torture. Ripping out their hair, mock executions, threatening to bury them alive, even drowning them and repeatedly resuscitating them so that you could drown them again up to 183 times over the course of 3 weeks was not considered torture. Under the Bush administration, torture was conducted at least at the CIA black sites. Unconfirmed reports at the time pegged the number of detainees at the black sites as high as 15,000 around the world. Torture also happened at Guantanamo Bay, where it continues under the Obama administration. And if you look particularly beyond those specific instances, there are bodies, including the City Council of Chicago, or I should say the Chicago Board of Aldermen, which have acknowledged that extended solitary confinement is an example of torture. And it happens pervasively across the U.S. prison system. So the idea that we are not a torturing society and that we left that chapter behind in 2008 is a bit far-fetched. We are a country that is as committed to torture as we are, unfortunately, to mass surveillance. I am going to leave aside the U.S. prison context for the purpose of today's talk, and I don't mean to create a false distinction there. I would absolutely agree that human rights principles in the U.S. prison context are routinely offended when individuals are isolated so long that they lose their minds, and that's what happens in extended solitary confinement. But just for the purposes of our discussion, to locate this institutionally, let's look at the CIA in particular. All right, so we know that, and to your point with respect to effectiveness, professional interrogators, which is to say not the CIA people who were handpicked by Dick Cheney to effectuate the program, but the people who had done interrogation at the FBI and the CIA and within the Pentagon for years, uniformly to a T, agree that torture is an ineffective means of interrogation, particularly because when someone's ripping out your fingernails, you'll tell them anything. Right? It's not a particularly probative means of gathering intelligence information. I'd invite you to think of torture through another lens. Don't think of torture as a human rights abuse, and don't think of torture as an interrogation method. Think about torture as a means to ensure that everyone who the state touches ends up guilty. That's what torture is. Torture is a means to ensure that there are no sympathetic characters. It's this insulation of the surrounding legal superstructure to keep it from being susceptible to democratic challenge. That's what torture is. Torture and mass surveillance each you could conceptualize as nails in the coffin on democracy because, for instance, let's take the United States out of it and consider a hypothetical authoritarian state. Mass surveillance is the means through which to ensure that domestic social movements don't emerge that could destabilize ruling power infrastructure. Torture is a means to ensure that anyone who is detained is eventually considered guilty. Right? Those two things together can intersect in very disturbing ways that we have seen in the world before I'm going to leave that aside and focus on the current time slice and corruption. So let's fast forward on the CIA. So the same way that Edward Snowden revealed NSA spying to the American public, the only reason we know about CIA spying is because there were some, I wouldn't even say whistleblowers, these were basically people complicit in torture who were stupid enough to share their photos. And we also know that the Defense Department has thousands of more photos. In addition to at least some videotapes, we know that the CIA destroyed most of the evidence. The videotaped evidence of torture was destroyed by a particular CIA official who remains free and brags about his acts in public. The thousands of photos that the Defense Department has documenting torture, far more severe than anything we have acknowledged publicly, were ordered released by multiple federal judges under a series of FOIA, Freedom of Information Act suits in 2009. In the fall of 2010, so the 2009 or 2010, Congress amended the Freedom of Information Act statutorily, essentially to overrule the courts on this precise question, giving the Defense Department the statutory authority to hide evidence of its criminal trail. That's the current state of the law. So just like Snowden released documents exposing a lot of things to us, in the CIA context, we've seen only a tiny infinitesimal amount of the evidence. The Senate Intelligence Committee, performing its function for once, conducted a multi-year, $40 million investigation compiling a 6,000-page report about torture by the CIA under the Bush administration. No one outside the CIA and the intelligence community has seen it. It's a secret report. It remains classified. At the highest levels of the administration, the president has had the opportunity to declassify it now since December 2012. He has not yet done so. The latest controversy emerged because the chair of the Senate Intelligence Committee took to the Senate floor, it would have been either last Tuesday or possibly the Tuesday before that, in the last 2 weeks, and said in public that the CIA had been stealing documents from her committee, impeding the investigation, trying not only to keep the report from being released to the public, but stealing the documents that the Intelligence Committee had gathered to buttress its report. That's all I'm going to say with respect to the facts. I do have a few lenses to introduce here. So let's just go back in history now. Well, questions first on the CIA facts before we get into analysis and start considering this normatively and what some of this implies. Go ahead.
For the NSA, I know that you said that Bush implemented the watered down allowing for torture. For the NSA, for the oversight, more watered down version, was that implemented under the Bush administration or the Obama administration?
The Bush administration, yeah. Fascinating history here. So I think it was spring of 2002, not long after the attacks, there's this famous story that the then, I believe, Deputy Attorney General James Comey discussed before being appointed to a more illustrious position since. So before he became the director of the FBI, this individual, when serving in the senior ranks of the Justice Department, testified before Congress in 2005, later, but 3 years before, only a few months after the attacks, he had to race the White House counsel, Andrew Card, up the steps of George Washington University Hospital to get to the Attorney General, who was recovering after surgery, to keep the White House counsel from pressuring the Attorney General while sedated into signing off on this program. The DAG got there first, James Comey. The Attorney General famously, when pressed for his signature, said the Attorney General's over there, pointing at James Comey. Comey refused to sign the document. The entire leadership of the Justice Department and the FBI threatened to resign under the Bush administration. These were Bush's picked appointees to the Justice Department and the FBI who threatened to resign because what was then called the Terrorist Surveillance Program, the TSP, was so abusive to civil liberties. No one knows what that version of the program was, nor does anybody know what changes were suggested or implemented. At some point, those officials stood down on their resignation threat and some version of the TSP was implemented. At the time, it was all secret. None of this was known to Congress. None of this was known to the courts. It was in flagrant violation of the Foreign Intelligence Surveillance Act before the 2008 amendments then legalized it. So this history here is interesting. So Congress in the 1970s says you cannot do this. In 2002 says the president, we're going to do it anyway. In 2005 is the first time anyone hears a whiff of any of this in public. The New York Times releases a report in December, just as the Chief Justice is being confirmed to the Supreme Court, almost derailing his nomination about the creation of this surveillance program, which proves incredibly incendiary. Fast forward, 3 years later, so when most of us violate a law, what happens? There's some kind of consequence, right? Okay, if the NSA and the FBI violate the law, you just have to wait 3 years and then Congress changes the law to enable everything you were doing before. Even though, and don't forget, the law of the land includes not only congressional statutes, but the Constitution too, right? Every federal court ever to have reviewed the NSA spying program on its merits has struck it down as unconstitutional, with one exception, and that was in December. A judge in the Southern District of New York, in a preliminary injunction context, said that there was nothing to see here, move along, and that decision is now going up on appeal. As is a contending case out of the D.C. Circuit, which is also up on appeal, and that judge described the NSA's domestic spying operations as, quote, almost Orwellian. And these are federal judges, right? So when the Article III judiciary has had an opportunity to voice its concerns, it has been very assertive. Each of those decisions were ultimately reversed on appeal, specifically on standing grounds, right? So follow me here. I said before that every court that reached the merits found the program unconstitutional, right? There are a variety of ways through which courts can avoid reaching the merits of a particular legal question. Constitutional standing or the state secrets privilege are two examples that in the national security context have repeatedly impeded judicial review from reaching the merits of these very important questions. Does anybody remember Clapper versus Amnesty, spring of 2013? So let me just lay this out for you. Just a few weeks before the Snowden revelations that we were talking about a few minutes ago, just a few weeks before Edward Snowden revealed NSA spying to the public, the Supreme Court ruled on a case challenging pervasive dragnet NSA spying. And what the Supreme Court ruled was, you can't prove that you're being spied on. So you have no controversy. You have the same interest that everybody else does, which doesn't meet the Article III standing barrier, because you, the plaintiffs, in this case, Amnesty International and a series of journalists and lawyers who represent Guantanamo detainees and their families, in some respects, exactly who you would want the NSA to be spying on. Like the people in the, if the NSA is spying like concentric circles, these are people as close to the center of the target as you would imagine. And the Supreme Court said they had nothing. They had no case because they could not prove that they were being spied on. Weeks later, Snowden reveals to the public that all of us are being spied on, not just those people and them too, but everybody else. And the one upshot I would say of that is it gave us standing, the Bill of Rights Defense Committee, to file a suit against the National Security Agency, in which we're being represented by the Electronic Frontier Foundation alongside 20 other plaintiffs, as diverse as the First Unitarian Church of Los Angeles and the California Gun Owners Association. So you sort of see this very wide swath, I should say, of America uniting around these very fundamental privacy interests. Where to go there? Two pieces. So just on the courts piece, I do want you to observe in the Clapper case what I would describe as the abdication of the judicial function. Courts play a role in our society. They have a crucial role in the constitutional design. The founders talked about it explicitly in the Federalist Papers, the need for an independent judiciary to breathe life into the principles that the Constitution embodies and the Congress enacts. If the courts aren't independent, the rest of it is kind of just for show. That's what the NSA saga teaches us. You can have a First Amendment, you can have a Foreign Intelligence Surveillance Act, you can have all the bells and whistles you want, but when you have secret courts that only hear from the government, they don't do you much good. Right? And when you try to take to the public courts to actually vindicate your rights, what the public courts say is, this is all secret, we don't get to see any of this, there's nothing we can do about this. Okay, so I want to step now into this week in particular. There's been some big news. Has anybody heard the news about the president's proposal and want to share it? I can summarize it if not. Go ahead.
Well, essentially, Obama's proposing impose some cutbacks on how far-reaching NSA's powers have been. There's nothing been proposed yet. But if I understand it correctly, he would require that the NSA have, permission from a court before seeking some records.
That's right, and that's a big deal, and you absolutely nailed it. And I think it's important to note that the president's proposal is meaningful with respect to curtailing the NSA's telephony metadata program. I'm going to try to zoom in on what the president's proposing. I'm going to contrast it with a series of proposed congressional measures, and then we're going to take a lens normatively at the sufficiency of those various proposed alternatives. So right, the president proposed to curtail parts of the NSA's telephone spying program, and the particular changes he suggested, one, the biggest deal is judicial review. The NSA, whereas currently the NSA can collect and retain data and query it unilaterally, there have been dozens of cases of NSA agents using the government's formidable powers to spy and stalk on their ex-lovers. That would end, because it would at least force the NSA to go to a judge and say, we need this for some reason. It would also be very different in that it would force the NSA no longer to retain data. Telecom companies would instead retain it, right? we'll get normatively in a second to what that entails. So it moves collection, or I should say retention, from the NSA to the telecom companies. It subjects a judicial warrant requirement for the first time to NSA queries of the database. And let's just leave it at that. I want to get into what this means relative to the other proposals. There's also a proposal by Representative Ruppersberger and Rogers. These are the chairs of the Senate and House, pardon me, the House, the chair and the ranking member of the House Intelligence Committee. Is anybody familiar with that? Go for it.
It's the same thing, kind of plans to curtail, but if I'm correct, they don't require approval by a judge, right?
Absolutely. No, I'd love to talk to you afterward. You absolutely seized on the distinction. And the only place I'd push back is that it does purport to end bulk data collection, but it doesn't actually do it. So the Ruppersberger-Rogers bill is called the End Bulk Collection Act. And like the president's proposal, it would restrain the NSA from retaining the data that it collects. And it would particularly put that data retention in the hands of the telecom companies, unlike the president's proposal. The intelligence committees, which remember were founded to oversee and check and balance executive agencies run amok, the intelligence committee proposal would give the NSA the unilateral right, instead of querying its own databases, to submit administrative subpoenas to the telecom companies to just gain access to whatever call records it wants. So not a meaningful check or balance. It's a shift in retention authority from the public secret agency to the private constitutionally unaccountable corporation, which is to say it could be a move from the frying pan into the fire. The NSA is secret and certainly committed to lawlessness, but at least it is theoretically accountable to the public. Congress writes the checks, right? Who writes the checks at the telecom companies? Is there state action by telecom companies of the sort that would implicate constitutional protections if violated? That's the key question. Any answers? It's a single word, starts with an N. Right? So that's the backstory on the current proposals. I want to contrast them with a series of others, two others. The first is the USA Freedom Act, introduced by Senators Patrick Leahy and Representative James Sensenbrenner. They are the chairs of the Senate and the House Judiciary Committees. And then finally, the Surveillance State Repeal Act, proposed by Representative Rush Holt, who used to chair the House Intelligence Committee until he was removed by Nancy Pelosi for doing his job too effectively. So the USA Freedom, and I wish that was hyperbole, you know. What do you say? All right, so the USA Freedom Act would encompass each of the different things we've talked about. It would go a good deal further. It is the only two bills in Congress, the two I'm about to discuss, are the only ones that would actually end bulk collection. And you'll see a lot of spin and obfuscation on these issues. We talked before about the Ruppersberger-Rogers bill called the End Bulk Collection Act, which does anything but. There's another bill by Senator Feinstein, who chairs the Senate Intelligence Committee, called the Fisa Improvements Act, which also is a red herring. The bill on which to focus, if you're interested in these issues, or if you're inclined at any point to potentially reach out to your elected representatives in Congress, is the USA Freedom Act. A couple things I want to draw out about it. First, it was written by the authors of the Patriot Act because they felt that their signature legislative achievement was abused by the government. So this is hardly a bill written by raging civil libertarians. These are the authors of the Patriot Act said, we want this to rein in the government powers to actually effectuate what we thought we were enacting back in 2002. I do think it's a little cute for James Sensenbrenner to claim that they didn't think that Section 215 was going to become a mass surveillance authority, but take them at their word. It would end bulk collection. It would require a judicial warrant for the NSA to gain access to call records. It would also require a relevance standard. It would require the NSA for the first time ever in the decade of operating this program to establish for anyone that what they're looking for is actually relevant to a terrorism investigation. Does that seem particularly constraining to legitimate national security counterterrorism efforts? It's not a particularly demanding request. Which is to say, when you hear about the program's necessity and the dire threat to national security that the contemporary debate portends, realize that it's not national security we're talking about there. It is the job security of government officials who are engaged in mass violations of constitutional rights. The reform proposals allow ample space for the government to conduct surveillance operations tethered to some legitimate counterterrorism purpose. The other things the USA Freedom Act would do is enable the Fisa Court to, for the first time, hear from an impartial public advocate, not someone representing the targets of a surveillance request, because of course in the intelligence context that creates problems, but at least someone who's there to argue to the court in favor of the privacy implications of these surveillance orders. And let's be clear, these surveillance orders often implicate hundreds of millions of Americans at once. They're not targeted to particular individuals. We skipped past this before, but it's worth just pausing and going back. The president's proposal, among the other things useful in it, is that he would narrow the 3-hop theory. If the NSA looks for a particular target, at the current time slice, they can look for one layer out, a second, and then a third. And anybody who's played the 6 degrees of separation game knows, 3 degrees of separation gets you more or less everybody. When the president issues his proposal, the public release or leak of what his proposal will entail suggests that he will narrow it from 3 to 2. That's meaningful. But contrasting with the USA Freedom Act, the president's proposals are at the very least, while important, very long overdue. He issued a promise in writing to examine NSA spying in July 2008 before ever winning the White House. So for him 6 years later to finally say that he's had an awakening and is proposing this important but relatively limited reform is at least 6 years and dozens of billions of dollars short. I want to note particularly that neither the president's proposal, nor the intelligence agency's proposals, nor even the USA Freedom Act would do anything at all about internet surveillance. Remember that. If there's anything you take away from this discussion with respect to the news that you'll be hearing about over the next few weeks, it is that. While the telephony metadata program is finally drawing enough controversy for several DC institutions to be lining up proposing competing reforms, internet surveillance is entrenched. No one's touching it. There is one bill in Congress that would address it. That's the Surveillance State Repeal Act. I referred to it before, introduced by Rush Holt. He was the chair of the House Intelligence Committee until under the Bush administration, when he was conducting very vigorous oversight. The then leader of the House, the Speaker of the House, Nancy Pelosi, removed him from the committee so that he could no longer exercise its oversight function. And he's written bills in each session of Congress since to repeal the Patriot Act in its entirety and the Foreign Intelligence Surveillance Act. It's the one bill that would end not just bulk telephony metadata collection, but internet surveillance too. So I just want you guys to grip that very tightly. Again, that's the Surveillance State Repeal Act. And I will note that it currently does not have a Republican co-sponsor in the House. So if you happen to live in Texas, you might have particular influence with respect to these issues. It's Tuesday, right? What day is it? Tuesday? Wednesday. I've been on the road, sorry. So tomorrow, the Senate Intelligence Committee is going to vote on whether to release the CIA torture report to the public. This is very much in live time. The CIA and the Senate Intelligence Committee have each sought Justice Department investigations into potential abuses by the other. The CIA is basically trying to intimidate the Senate saying, you don't have a right to keep these documents from us, and even if you did, what are you doing accusing us of espionage for doing our jobs? And so you'll find out tomorrow. Tomorrow will be a very crucial test about whether or not there is any meaningful transparency in these issues. Well, actually, let me rephrase that. We know there is not any meaningful transparency in these issues. Tomorrow will be a crucial test as to whether or not there will at least be lip service paid to the principle of transparency or not. I'm just rambling at you now, so let me pause, take questions. I haven't really focused on the corruption piece yet, and I hope to in response to your questions, but I would love to hear what each of you think, either about these respective issues, NSA spying, CIA torture, or particularly how they relate to each other and the operation of the institutions in Washington that we've been discussing.
You stated, I believe it was called the USA legislation.
USA Freedom Act.
USA Freedom Act, and that mandates that we need a judiciary warrant to collect metadata.
It doesn't require a warrant for collection, it requires a warrant for analysis. So the Fourth Amendment, right, protects from unreasonable searches and seizures, and there's a whole body of jurisprudence about what constitutes a search. In the intelligence collection context, there's a Supreme Court case from 1979 that's been widely misinterpreted to allow metadata collection without it constituting a search. The government has contended, and at this point Congress has accepted, that a search only happens when you look at it, when a human being looks at the database to examine it. That's the point at which a search inheres under, again, a jurisprudence that remains confused.
But my question is, will these warrants be coming from the Fisa Court?
Yeah.
So at the same time, isn't there already a program in place for them? Even though they hear from the one side of the federal government, that's still the process to which they go through.
Close. At the moment, they don't have to actually get warrants to secure it. The NSA can do it unilaterally. What happens in the Fisa Court currently is it's a little bit different than that. It's the approval for mass surveillance orders, specifically under Section 215.
Okay.
All of the internet surveillance, the 702 programs, the PRISM program, the X-Keyscore program, Stellar Wind, none of that requires judicial warrant. So the Fisa Court process is confined to one piece of the equation, and what the USA Freedom Act would do is maintain that process, but enable transparency in it. So, for instance, when the Fisa Court judges are hearing from the government, they would also hear from someone else who is basically the equivalent of like a public defender. And it's somewhat different. They wouldn't be representing the individuals or the groups targeted, but they'd be representing the abstract value of privacy.
But the court would remain, that would
Yeah.
be the institution people want.
That's right. And to that point, I would even say that even the USA Freedom Act leaves a great deal to be desired. But relative to the landscape of red herring, co-opting, bait and switch alternatives, it's the best thing on the table. Please.
Just a broad theoretical question. So we are supposed to be a republic, it's even in the preamble of the Constitution. And in the Constitution, Congress has the power to delegate authority to these agencies. However, the American people don't have any way to hold these agencies accountable because they cannot be reelected like senators or House representatives. So is it fair to say that the congressmen are using a constitutional power to promote unconstitutionality?
Fascinating. Yes. Yeah, I mean, what you're basically observing is a passing the buck. You have democratically democratically accountable elected officials who are deferring to insulated actors, that is to say agency officials who are not answerable to the public, to conduct operations that they would not want their hands on. One sort of gloss on that that's worth noting is that at the very least, the intelligence committees have been complicit, because they were read into these issues as early as the Bush administration. The chair of the Senate Intelligence Committee at the time, Senator Jay Rockefeller, when news of the program finally leaked in 2005, the New York Times report I mentioned, in which the journalists who revealed the program to the public were threatened with prosecution for performing their jobs. At the time, the chair of the Senate Intelligence Committee then took to the press with a note he had written to himself and stuffed in his desk saying, "You've briefed me on these programs, but denied me the right to have counsel or technologist present, so I really don't have any idea if this is okay or problematic, but I'm not going to say anything about it either. I'm just going to write myself this note, stick it in my drawer, and when it becomes public, I'm going to give it to the press then," to suggest that I actually had concerns. So to your point about democratic unaccountability of elected officials who are basically ducking these issues, and I dare say that the president is in the same boat, right? I mean, if you think about the broad historical sweep from the civil rights era, when we know that the intelligence agencies were spying on civil rights leaders, to the election of the first black president, who then becomes complicit in the extension of these programs, their adoption not just as a tool of a single administration representing one political party, but rather a tool of administrations across both major political parties, it is a disturbing inversion of a historical arc. Lon?
Do you think it may be an overreach, or maybe not, to think that maybe the president has become complicit in order to not be assassinated?
Just given where we're standing geographically, I don't think it's a stretch at all. No, I mean, we've seen presidents assassinated not far from here before. I mean, laugh if you want to. It doesn't strike me as terribly funny, but yeah, I don't think it's crazy at all. At the very least, I mean, there's outright physical, like life assassination versus political assassination, and I think it's at least very easy to say that anyone in an elected position who opposes the NSA will commit political self-assassination, because this is what made J. Edgar Hoover so dangerous during the COINTELPRO era. The FBI had dossiers on every member of Congress. Elected officials were basically blackmailed, going to your point, were basically the ones who were inclined to defer to the constitutional interests at stake, were often blackmailed into supporting the intelligence agencies, right? The NSA has capabilities to that extent vastly beyond what the FBI did at the time. And you'll hear a lot of people say that the NSA's activities have been subject to rigorous oversight. The rigorous oversight is of the kind when Congress is writing notes to themselves in desks because they can't actually look at the evidence, and the court's hearing from one side of the issue and issuing decisions in secret. That's the kind of oversight that these programs have had. And you'll also hear people say that, like the torture programs, your colleague in the back, had heard some propaganda about the effectiveness of the torture programs. And these are claims that cannot be sustained in public. That's why the Snowden revelations were so transformative, because the institutions, the executive branch, the congressional oversight committees, and the contrived so-called court, had all lined up behind a consensus that cannot fly before the public. And that's another thing to take away from this discussion, and I want to loop that back to the frame about corruption. What do you call it when decisions are made in secret, reflecting a consensus among bodies created to check and balance each other, and that consensus violates the public understanding across the political spectrum once it's revealed? Let me just throw some more data points at you. What about if executive officials, when finally called before Congress to account for these issues, then intentionally lie about them and mislead Congress about the scope of domestic surveillance? That happened. And the official who lied to Congress remains the Director of National Intelligence, despite multiple calls from members of Congress on both sides of the aisle for his appropriate prosecution for lying to the public. What do you call it when executive agencies create powers in violation of federal statutes, game the system, hide for a decade, misappropriate dozens of billions of dollars in taxpayer funds, and then lie to Congress about it when finally called on the table? Is there any word for that other than corruption?
Treason?
Sure. I mean, I didn't say it, but yeah, sure, why not? The shoe fits.
Just out of curiosity, how substantial is the evidence that states the use of these NSA practices has not helped the United States as a general do preemptive strikes on terrorist organizations or,
Yep, that's a good question. Most of the evidence is secret. What little we know is derived from the reports by the bodies that have been built to examine these issues. I should note before, just as we're wrapping up, that I do have sign-up sheets here, I think Colin might, through which I would love to, they're over this way. And in fact, could I just maybe pass these down the row? I'd love for you guys to have these. If anything I'm sharing with you is new, if you haven't heard any of this, I have a very strong interest in you hearing whatever else you're not hearing. And I do think, this might be heavy-handed, but follow me here. You're law students, right? You have a particular privilege in our society. People often forget. You might think, to my point about Sahar Aziz earlier, that your lives are rough. You have immense social privileges because you have both the training to understand these issues in a way that most people don't, and it might not feel like this at the time, but you have the time to actually grapple with it. Lawyers in private practice don't have opportunities generally to raise their voices unless they're very assertive about carving out time outside the context of their professional responsibilities. People who aren't lawyers will have a very hard time parsing these issues, particularly because, as we're talking about them, you noted, for instance, this interplay between the executive, judicial, and constitutional. It takes some background to understand how those things fit together, how the constitutional principles relate to the news stories, which are usually presented as isolated moments in time without historical context. You are uniquely situated to be guardians of our nation's most fundamental values. I dare say beyond training for a profession, your time in law school, that's what it prepares you to do, is to be hyper citizens. Each of you are that. Silence from anyone is a political choice in the face of a sustained abuse, right? To not raise your voice in the face of something that is obviously wrong is to be complicit in it. You are each hyper-empowered. I would implore each of you to take every advantage of the opportunities to raise your voice, and I can think of dozens. Everything from writing in your individual capacities, your notes for the law review, right? You could address these kinds of issues. You could develop scholarship around these issues. You could be writing op-eds for the local paper around these issues. I'm speaking this evening at an event hosted by the Dallas Peace Center, the former executive director of which is here in the room today. He also represents you in the state legislature, Representative Von Burnham. I'm sure that he could point you to a number of opportunities to essentially raise your voice. You have opportunities, and I'm not saying 10 years from now, I mean now, as law students. You will lose opportunities to raise your voice as you continue, quite likely, through your professions. And maybe just with that, I'd love to entertain any other questions you guys might have, or that Sahar might have.
Go ahead.
It seems like these institutions and their systemic practices have been here for a significant period of time, and I don't necessarily see them going anywhere, even with legislation modifications.
Yep.
Going forward, if in fact legislation passes that kind of hinder or hamstring their capacity to do what they're doing, how do you ensure that that actually is enforced and they don't actually move into deeper into the realm of like secrecy?
It's a great question, and to be perfectly frank, there are holes in the bottom of the constitutional bucket, and that's what you're observing. The claim that intelligence or covert operations require secrecy is itself that once you get to secrecy as a legitimate executive function, all bets at that point are off, and you pretty much are relying on the goodwill of the actors involved, and that was a problem. That's why the Senate and the House created the intelligence committees, because they tried to close that down, right? Fast forward to the Iran-Contra Scandal, right? The executive branch does things in secret that no one would agree with. It's inherent in some respects, and it shouldn't surprise us. I mean, a U.S. president who served in no other capacity, in a capacity no less illustrious than the Supreme Allied Commander in World War II, there was any leader in the last century who we would describe as a bona fide hero, it would be General Dwight Eisenhower. He warned in explicit terms, the last thing he said to the American public as a president, his departing address in 1961, he warned that there was emerging a military-industrial complex. He coined the term, and he predicted that it would destabilize democracy. He said in 1961 that we had to be vigilant about our freedoms, and we have not been. And his prediction has absolutely become true. What is the NSA if not the military-industrial complex turning its fangs on the American people? Let's unpack it. Military industry, right? There's the Pentagon and the NSA and the set of agencies in it. The industry piece of the telecom companies, which is why you should be so disturbed by the President's proposal and the Ruppersberger-Rogers proposal to move the retention capacity from the NSA to the private sector. It's no better, and in some cases, it's much worse, because you don't have constitutional rights vis-a-vis those institutions, right? It could be out of the frying pan and into the fire, in addition to being meager and under-inclusive and 10 years late. So to your point, yes, I think the intelligence agencies are inherently problematic for a republic, to your point from before. They don't quite fit in a free society. And I'll just give it to you this way. Another issue, Sahar had mentioned that in her class in the fall, drone strikes are going to be an issue that you'll examine. There's Alex Wagner, Alex something, I think it's Wagner, it might be Wagner. He's in the Defense Department now. He's a aspiring academic who works in the Pentagon and has a paper out, co-authored with another name who I can't recall. His paper examines CIA drone strikes, and this was written again by a Pentagon lawyer, noting that CIA operatives conducting drone strikes have the same legal status as Al-Qaeda operatives. They're non-state actors, not operating in the legitimate authority of the military, right? I mean, what you're basically acknowledging is that our intelligence agencies are legally indistinguishable from the people that they claim to be fighting while spying on their ex-girlfriends, right? And that should disturb us, because they're getting paid with your tax money, and they're abusing your rights, and then lying about it on the rare occasion that anybody actually finds out what they're doing in secret. Again, I would love for anybody to come up with another word other than treason or corruption to describe that. But that is the state of the law as we find it. And so as you're examining and exploring what passes for law in our country, I would just hope that you, again, place what you're learning in a context and recognize, I want to stop short of saying illegitimacy, because that's a strong word, at least recognize the gulf between the rhetoric and the reality surrounding these issues. And I would love also to entertain your questions now. If anyone wants to hang out and pose questions after, I'm happy to hang out for a few minutes. And please stay in touch with our work at the Bill of Rights Defense Committee. Our work is to help you raise your voices, and I'm hoping very much to help you. Thank you.
Well, that was moving and inspiring. I think I'm going to go back to practice. So I just want to end and say that you can be the change you seek. Hopefully you come out of this feeling very frustrated, angry, disempowered, because this stuff is very problematic. It's very troubling. It's been going on for at least 13 years. And whether you're going to go through the Federalist Society, ACS, Women's Law Association, International Law Students, it doesn't matter. Go through an organization, work together, and make this law school a center for social change. And you have to do it. It can't be imposed by the professors. We can facilitate it, we can bring you the fantastic speakers, we have access to renowned experts across the country, but you all have to be the drivers of change, and it's your generation that is going to be dealing with this stuff for quite a while. So I want you to think about what kind of conferences you want to hold, whether you want to bring in the local community and educate them about these issues, whether you want to get involved with your political representative, whatever it is you're going to do. But let's do something beyond just getting a JD and a piece of paper and going and making money and being silent. Okay? All right, so I will see you in the fall. Oh, and I'd like to introduce, I'm sorry, our representative, Lon Burnham.
Hey, I'm Lon Burnham, and I represented the law school until you changed to A&M. No, I represented the law school until I did redistricting and took downtown out of the district. But I just want to echo that sentiment. And here is where it was for me as an undergraduate in school, thinking, well, we're going to be killed by the nuclear holocaust, and I better get to work and stop it now. We haven't had that nuclear holocaust yet, but we have had a steady erosion of our constitutional rights since President Eisenhower warned us about that. There is no time like the present. You are in a particular point of privilege. You're in law school, and a Canadian friend of mine reminded me years ago, Americans undervalue their privilege and fail to recognize your position in society. You are privileged by the level of education you've already attained, the level of education you're pursuing, and you can make a difference today and tomorrow. If you're free this evening, I invite you to come to the meeting at the La Madeleine next to the SMU campus. Not as good a law school as you guys have, but right next to the law school at SMU. The Constitution is under attack. There's a half dozen organizations here working here in North Texas to defend that Constitution. Be a part of the solution. Don't just sit there and take it.
I'll see you all in my fall national security class.
And if anybody wants any food, there's some extra. And please, we can continue doing this with your support. So sign up sheets and membership.
Yeah, well,